SJC-12633, Commonwealth v. Izara L. Wentworth.
Ms. LeClaire, good morning.
Good morning, Chief Justice, and may it please the Court. Jessica LeClaire for Izara Wentworth. I thought I would begin with the first question this Court posed for amicus solicitation, which is whether the Beale rule should be applied retroactively. And our position is that the Constitution actually requires retroactive application. This Court, as a matter of state law, has adopted the Supreme Court's retroactivity analysis as espoused in Teague. And under that analysis, we ask, is the rule new, is it constitutional, and is it procedural or is it substantive? And if it's substantive, what the Supreme Court said in Montgomery v. Louisiana is the state collateral review courts must apply that rule retroactively. The Beale rule fits this criteria. First of all, it was a new rule. It was not dictated by prior precedent. And second, it was constitutional. The residual clause of what I will refer to as 10G was deemed unconstitutionally vague. And finally, it's substantive. And that's the most important point, because what that rule did is it significantly narrowed the actual conduct that can be punished under 10G. And it also narrowed the class of defendants who could come within the scope of that statute. So it regulated primary conduct, and it essentially said, this conduct, the state no longer has the power to punish this conduct that falls within the residual clause, but doesn't fall within some other provision of 10G.
Well, your sister says you're probably right, but it doesn't matter because what was focused on here was not the residual clause, but the conclusion that the defendant had committed a harmful assault and battery, and that pursuant to Eberhardt falls within the scope of a violent crime. So why don't we focus on that?
Yes, Your Honor.
Issue. And I guess before you get there, do you endorse the arguments of the amicus brief?
Yes, Your Honor.
So do you view those to be essentially a separate articulation of your arguments, or are they a separate and distinct argument from what you're arguing?
We agree with the CPCS amicus brief position, yes, Your Honor. And
Essentially that we got it wrong in Eberhardt and Beale?
I don't think it's that you got it wrong. I think the holdings in those cases were correct, but there was dicta that tended to indicate that under the force clause or under the 10G as a whole, we can look at the means by which a defendant commits a crime. And what the Supreme Court has said in Mathis and DeCamp is it's important for us to distinguish between what is an element and what is a means. And so in Eberhardt, the court adopted the categorical approach, and it adopted the modified categorical approach, and it has consistently endorsed that approach.
So can you talk a little bit more about the modified approach and how would that apply and what would it look like?
So under the modified categorical approach, the task for the adjudicator is exactly the same. What we're looking at is, first of all, what is the offense of which the defendant was convicted? And we can look to the records to determine that. But we need to know precisely what offense the defendant was convicted of. Then, under the force clause, by its plain text, we say, what were the elements of that offense? Now, the modified categorical approach only comes into play if that statutory provision covers a number of different crimes. And at that point, we have to decide
And
which...
didn't we say that it covers these different forms of assault and battery, right? I understand it's dictum in a sense, but we basically did your case, didn't we? We may have gotten it wrong, but don't we have to reverse everything we said in those two cases to get to get to where you want to be?
I think we have to clarify what those cases said. And what they said is, what they suggested is that harmful, reckless, and intentional battery are separate crimes. But what the Supreme Court clarified in Mathis and DeCamp is actually, when we ask what is an element, we're asking what was it that the government was legally required to prove. We don't ask what did the defendant actually do, and we don't ask what was it that was the government's theory of the case. Did the defendant actually use violence? So if we look at the elements of assault and battery, when the jury is instructed to find whether or not a defendant has committed an assault and battery, they're advised you can find either a harmful or an offensive contact. Those are alternative ways that the jury can find what did the defendant do.
Well, I don't remember instructing on offensive unless offensive was, in the light most favorable to the Commonwealth, available on the facts. You don't instruct on the alternative if it's not applicable to the case.
Well, the model jury instructions.
I know that the first model jury instructions are not models in Superior Court, and it's not a good idea to tell the jury from the model jury instructions, indecent A and B on over 14, it might have 7 elements as I remember it, and it's really 2 or 3 depending on how you give the instruction. There's just no reason to instruct on offensive touching if it's not an offensive touching. That's just not a good job of teaching the jury the law.
Well, if we look at the in that situation, we're going to be able to look at the jury instructions. The court can say, the defendant can say, I'm being charged with a prior violent crime of assault and battery, and I wasn't convicted of harmful. And we can go to look at the jury instructions and determine that, in fact, the jury wasn't instructed on the offensive form of assault and battery in that particular example. But most cases are resolved by plea. And so if I give you a hypothetical, let's say I have a client who says...
But the plea colloquy doesn't help you in your case, right?
I would disagree, Your Honor, and if I think this hypothetical will explain that. Let's say I have a defendant who says, well, I was at a bar and the bartender wasn't paying attention, so I tapped her on the cheek. And he's charged with assault and battery. And then the victim says, well, tells the prosecutor or she tells the police, he smacked me. Now he says it was just a tap. And she says, he smacked me. I'm going to tell that client, it doesn't matter. It's still assault and battery.
But
Your client was under oath and agreed that there was violence.
So what happens in the plea colloquy?
This is a conversation. Right. So
I want to, if we can keep going, then that under Rule 12, what the prosecutor does, the prosecutor has an obligation to recite the facts. It's the prosecutor's duty.
And the judge has an obligation to say, what the assistant district attorney just said, sir, is that what happened? And under oath, they say yes, or we have a jury trial.
Well, what happens is that defendant might internally or to their defense attorney contest the kind of force that was used.
So we have to build a doctrine
But that's
around.
not.
We have to build a doctrine around they might be lying or crossing their fingers behind their back when they answer the judge that is what happened.
No, what happens in the plea is by the Rule 12, the prosecutor controls the narrative. And if the defendant says, Your Honor, I just touched her, the defense attorney says, hey.
But well, haven't you been or seen pleas where they just blow up, where the defendant says, I didn't do that? I had a lot of pleas that blew up where the person says, I'm not gonna swear to that.
Right,
And
well-
whatever happens between defense counsel, and I take what you say is true, obviously. Whatever happens with defense counsel and the client is one thing, but there are plenty of people who say, I don't accept those facts. And we say, okay, fine. I'm not going to take your plea because you haven't pled.
Well, that's the problem, because a defendant who contests those facts the ins and outs and nuances of those facts might risk losing the plea colloquy. And what the court said in DeCamp and Mathis, the Supreme Court said, a defendant waives his right to a jury trial, and he waives his right not to incriminate himself only as to the elements of the crime. And that's important because whether force is violent or not violent is not an element of assault and battery.
Isn't the core, I mean, Eberhardt says that the modified categorical approach kicks in only when we can't be sure which elements of the crime are at issue, because there are different elements for different parts of the crime. Correct?
Yes.
And isn't the core decision we're here to make as to whether or not whether or not there are two types of assaults, intentional assaults, where the means are offensive or harmful, for which the element is intentional, versus reckless, put aside reckless as to whether or not reckless, which is, I think, not at issue here. No one contends that what is at issue is reckless, or whether or not the element is harmful or offensive. Because if the element is harmful, arguably, the plea colloquy makes clear, somewhat clear, one could say, that, oh, we're talking about the element of harmfulness. But if the element is intentional, then the intentional crime can be committed either by being offensive or being harmful. And therefore, because an offensive means is not within the statute, then the intentional element can't be a violent crime. Isn't that sort of the whole course, the whole source here?
Yes, Your Honor. An intentional assault and battery, our position is, can never be a violent crime because a defendant never has to admit, because whether or not the crime was committed harmfully is not a legally necessary prerequisite to obtaining that conviction. And a defendant who pleads guilty, let's say to an intentional assault and battery, has never been told that that plea also means he's agreeing that as to the kind of force that he used.
Someone that pleads guilty to an intentional assault and battery, your position is can never be a force crime?
It can never be a crime that has as an element a use of force.
So if someone punches someone in the face 13 times, that's not force?
It may, well, that's what we're talking about. When we talk about the force clause, we're not asking, did the defendant use violent force? At the subsequent offense trial, the task for the court or the jury is not to ask, did the defendant use violent force to commit that crime? The question is, was the government required to prove a violent use of force to commit that crime?
Can I switch you to your first issue? Because I'm actually more concerned about your first issue, because the indictment is probably one of the vaguest I've ever seen, right? The subsequent offense one. Basically, do you have the language in front of you? The language?
The indictment?
Yeah.
Yeah.
Basically just says there may be drug or other offenses or something like that, right?
It says, previously been convicted of 3 violent crimes or 3 serious drug offenses or any combination totaling 3 or more.
So that's clearly, that part's clearly just, it's tracking some kind of statutory language. Is that what that's doing?
That's tracking the language of 10G-C.
So then he pleads, is that fixable? Because at the guilty plea, they go through exactly what the basis is, right? It's the assault and battery. Does that fix that? I'm trying to give you a chance, because they've got to defend a really sloppy indictment, but I assume they're going to say it's cured at the guilty plea stage. What's your
Well,
response to that?
the first point is, we have a constitutional right to a grand jury indictment, so it's up to the grand jury to decide what those predicates are. So allowing the prosecutor to elect at the
We
police...
know at the grand jury, right, that they are presented with specifics, right?
They're presented with a number of 3 separate occasions,
Right.
but they're also presented with what may or may not be more than one conviction on those occasions. So they had a duty, it was up to the grand jury to decide which one of these which 3 of these, or less, do we think merit prosecution? And if those aren't specified in the indictment, a defendant has no opportunity to say, look, this one's not a violent crime, or no, this wasn't a serious drug offense.
At the
or
guilty, at the plea hearing, we find the specific example, the A and B on his wife, right? And that's not enough to fix this I mean, I understand substantively it may, but
it doesn't cure the error at the earlier stage, which is we don't know whether he was actually indicted for that one. It could have been 2 resisting arrests and carrying a dangerous weapon. It doesn't cure the fact that, an effective attorney would have had an opportunity to move to dismiss that because no violence.
by being ineffective, you're probably worth the most effective, right? Because if you'd brought it forward with a bill of particulars, you would have been dead, because he's got plenty of prior convictions, right? So this was actually good lawyering by leaving it out.
Well, I'm not aware of it anywhere in the record. It says he has plenty of convictions. The judge suggests he's been before the court on arrests, but that would only give, a bill of particulars would mean that would show what the prosecutor thought were the predicates, but it wouldn't cure the fact that the grand jury didn't decide.
Well, but the grand jury does get plenty of evidence on that. It's the initial defect you say is incurable, is that basically your argument?
I'm saying that, that it's an incurable defect because he wasn't actually on notice as to what the grand jury indicted him
That's what I was going to
for.
ask you. It's two issues for harm. One is the right to have a felony presented to the grand jury, and the second is due process notice.
That's right.
Of what's being charged.
That's right.
Okay,
If there are no more questions, thank you, Your Honor.
Ms. Horan.
Good morning, may it please the court. Assistant District Attorney Donna Marie Herron, representing the Commonwealth. I want to say, ask this court to affirm the judge's order denying the defendant's motion to vacate his armed career criminal sentence and conviction. I first would like to go to the modified category approach, if I may. The defendant is asking you to overrule Beal and Eberhardt, which you, in your ruling, specifically said that assault and battery, harmful and reckless, qualify as a violent crime under the force clause. And then you did adopt and allow the modified category approach when determining that. And if you look at, I'm going to mispronounce it, Descamp, the one that my sister keeps referring to, they actually have a really good explanation as to what the modified category approach does. And it states that the modified approach helps to implement the category approach when the defendant is convicted of violating a divisible statute. The modified approach thus is not an exception, but rather is used as a tool. It retains the category approach's central feature of focusing on the elements and not the facts. However, it preserves the basic it looks at the facts, but it allows you to determine which elements the defendant was convicted under, and that's exactly what we did here.
And which element do you say he was convicted of?
He was convicted under the harmful battery under the force clause.
And that assumes that the element is harmful as opposed to intentional, does it not?
Well, it's an intentional harmful battery versus an intentional offensive battery.
Okay.
It's the offensive.
Well, the problem you have is the district court jury instructions and Commonwealth versus Poro, both of which say that the element, I'm reading from the district court jury instructions, third element, that the touching was either likely to cause bodily harm to victim or was offensive and done without his or her consent. That's the third
Yes.
element.
And the modified category approach therefore allows the court, or the judge, in this case Judge Ricciardoni, to determine whether when the defendant pled guilty to assault and battery, did he plead guilty to the first part of that, the harmful battery, or did he plead guilty to the offensive battery? And the judge in his ruling then at the time, and clearly on his denial of the motion for new trial, said he unquestionably found that the defendant committed a harmful battery under the force clause when he struck his girlfriend in the face and then pushed her down on the bed.
Okay, well, let me ask you another question then. If there is a question of whether the conduct is harmful or offensive, do you tell the jury that they must be unanimous, or can 6 choose harmful and 6 choose offensive?
I would believe they have to be unanimous. I don't know how to answer that question, Your Honor, to be
But
quite
don't
frankly,
you-
because it depends on the facts of the
Don't you-
case.
No, that's a legal question.
Well, I would assume that the judge would give them the instruction as to what the assault and battery jury instruction, and then
Right,
tell
but
them they have to
and the
be,
third element says "or," which means that
which a lot of our,
half can choose offensive and half can choose harmful. Does it not?
yes, but quite frankly, a lot of our statutes have differing
But
or
doesn't that,
elements.
well, now I want to turn you to Mathis, which was decided after Eberhardt.
Yes, which also states you can use the modified category approach, but in that case did not, because burglary statute, which was under the enumerated, not the force clause, but under the enumerated clause, they found that the burglary, the elements were clear, and therefore you didn't have to get into the facts, because you used the, I don't remember what state, was it Iowa? The state's burglary statute and the generic burglary statute, and they found that the elements, you didn't have to look at the facts because you had the elements right there.
But look at the analysis in Mathis. Justice Kagan says you don't need to be, when we're deciding this issue, we're focusing on the elements, not the means. Correct?
Correct, because they didn't have to, because there
Right.
was no differing elements.
Okay, I understand. But then she says there's a way to distinguish between assault and means, which is that if it is means, the jury need not be unanimous. The jury can say, half may say it was by this means, half may say it was the other means, as long as all 12 or all 6 in the district court case find that the element is satisfied. So unanimity, the requirement for unanimity is what distinguishes an element from a means. Isn't that what Justice Kagan says in Mathis?
I take your word for that. I didn't read Mathis that fully because I didn't believe it supported the defendant's position.
Okay, I'll read it to you. This threshold inquiry, element or means, I'm reading from Justice Kagan's opinion, is easy in this case, as it will be in many others. Here, a state court definitively answers the question, the listed premises in Iowa's burglary statute are alternative methods of committing one offense so that a jury need not agree whether the burgled location was a building, other structure, or vehicle.
Yes, I do. I'm sorry, I understand your question better now. Sorry, Justice Gantz. But there was because there was no, she specifically said that elements were differing. It was just the manner of committing the elements. Well, with assault and battery, you have differing elements.
Right, but I guess, but to me, as far as I can tell, the core question here is if a jury can, if 6 can say it's offensive and 6 can say it is harmful, then the element is intentional, and offensive versus harmful are means as opposed to separate and distinct elements. Isn't that the core issue we have to decide in this case?
No, the core issue you have to decide is whether when the defendant pled guilty to being an armed career criminal, whether the Commonwealth proved when they said the recitation of facts that it was a violent crime under the force clause. That is what the issue that was before Judge Ricciardoni.
But you know that, you know that depends upon whether or not the element.
Yes, and that's when you use the modified category approach and you look at the facts to say, if our recitation was the defendant before you spit on his girlfriend and then something else nonviolent, then clearly we did not meet the violent clause under the, did not meet a violent crime under the force clause. That's where you look at the facts to determine which element the defendant was convicted under, which.
But you're still focusing on the issue that offensive is an element as opposed to intentional being the element, are you not?
I believe offensive is an element, Your Honor. It's one or two ways.
Element, if it's an element, then the jury has to be unanimous as
Yes.
to whether it's offensive or harmful.
Yes,
And you said before you didn't know.
but I'm changing my answer then now because I do, I just.
Well, I'll tell you, in the district court, the model jury instructions will tell you, unless they've changed since I looked previously, that you need a unanimity instruction and a special verdict for reckless. but harmful or offensive, you don't. And whether or not Mathis and this is dispositive of the issue, it wouldn't make any sense for 6 people to say, oh, it was harmful, 6 people to say it was offensive, or District Court 3 and 3, and then say, well, 6 of you think he's guilty, but it's not guilty because you don't agree on the means. So arguably, based on Chief Justice Gantz's questions from the case, this is really means when you're dealing with harmful as opposed to offensive in comparison to reckless versus intentional, which does require unanimity and a special verdict form.
But didn't we just say the opposite of that in Eberhardt? And I mean, I don't get it. Eberhardt made this very point, and Mathis is a U.S. Supreme Court case. We're departing from their approach, aren't we?
Well, Mathis wasn't just, Mathis was written in 2016.
Right, but it's also,
Eberhardt was 2012.
yeah, but I thought we said we were departing from the federal approach earlier, before Mathis. So the fact that Mathis changes, does that mean we have to change here?
I don't believe, because Mathis is looking at first the enumerated, whether it was burglary, and the way I read Mathis, and maybe I'm reading it wrong, was that we're looking slowly at the elements, and the elements of burglary, which I don't know off the top of my head, I apologize. The judge departed because he was looking at whether one of the elements was the factual basis as to whether they committed that element, and they said because there was no differing elements that the judge erred by doing that. And this court in Eberhardt and in Beale, and then the appeals court recently in Wildberg, again, stated that we fall, in Wildberg specifically, which this court denied FAR, stated that we're not gonna solely follow the federal there, that we're gonna look at the modified category approach in that harmful battery and reckless battery qualify as a violent crime under the force clause, and therefore it can qualify as an ACC under there. And I'm asking you to follow the holding of Beale, the holding of this court, and the holding of the appeals court in determining that a harmful battery, which the defendant clearly committed here, qualified as a violent crime under the force clause, and therefore supported the defendant's plea when he pled guilty to that in front of Judge Ricciardone.
Can I get the first issue? The indictment doesn't give you any information of what the basis, right?
The indictment tracks the statutory language of 10 GC, and it puts the defendant on.
That's not sufficient, right?
I would disagree with it, Your Honor.
Just quote, I mean, are we even dealing with drug issues in this case? I mean, just throwing in stuff, it may be drugs, it may be other things. We're gonna indict you as a armed career criminal. That's good enough?
Yes, you just
for
have to
government
put
work?
the defendant on notice that you're going to be seeking a sentence enhancement, and here we put the defendant on notice. We're going to be seeking a sentence enhancement under the, as a Category 3, at the time, as a Category 3 ACC.
As long as we say anything and say we're seeking a sentencing enhancement, that's enough for the indictment?
For the indictment, and then the defendant can ask for a bill of particulars, which he did not do in this case. He can, and in the grand jury minutes, I disagree with my sister. I think the prosecutor specifically laid out the conviction, the dates of the conviction, and what the specific.
Didn't we require more in Fernandez and Pagan than that?
No, Pagan,
Pagan, I guess they forget altogether, right?
in both of those, they don't even.
No, Fernandez, they have information there, right?
They do, and the court specifically stated in Fernandez that, in Pagan, they didn't. They didn't say at all that it was he was going to be subjected to, which is now, lifetime community parole, and that was the holding of Pagan, is that you have to at least put the defendant on notice that you are going to be seeking the sentence enhancement, which is what we followed here in this case when you listed that to put the defendant on notice that we'll be seeking an ACC level 3, putting him in notice.
You don't need to give him any information about what the basis for that is.
In the indictment, no, I don't think you do, because, again, you have the bill of particulars, you have the grand jury minutes. This defendant, and the plea colloquy shows this out, clearly knew what he was pleading guilty to, and he was on notice as to what the Commonwealth was alleging was the basis for the ACC. And in the cases cited in the Commonwealth's brief, you don't have to list every element, that it's actually not an element of the crime, it's a sentence enhancement, and the defendant just has to be put on notice. And then, therefore, by pleading guilty, the defendant has waived all non-jurisdictional defects, which that would be in this case, but the defendant was put on notice, we know, by the grand jury minutes of what crimes the Commonwealth was alleging was the ACC.
But going to the waiver issue, assuming that's not correct, going to the waiver issue, I guess the question is whether the notice issue is, as a matter of due process, required so that it couldn't be waived.
Yes, that would be, I agree that if you were to find that that was defective, then yes, he couldn't waive that. But I would suggest all the case law relied upon by the Commonwealth, that clearly by putting him on notice that we were seeking to indict him as an ACC level 3, that was all that was required in the indictment. And for the other reasons, as I stated, that if he had any confusion, he could have filed a bill of particulars, but the grand jury minutes, which he immediately gets, clearly cleared up exactly what the Commonwealth at the time was alleging was the basis for the ACC level 3.
Now, the three were A and B. Resisting arrest, was
I
that
think it
one?
was resisting arrest, and I believe it was carrying a dangerous weapon, but the defendant only pled guilty, as you know, to, that's why the Commonwealth restricts its brief to the assault and battery, because that was the only crime the defendant pled guilty to, as an ACC level 1.
And if the defendant had filed a McCarthy motion, do you agree that at the minimum, she would have been able to knock out 2 of the 3?
I can't say what they're resisting, or I'm not prepared to say they don't qualify as a violent crime under the force clause. I'm not prepared for that. They could have, could not. I'm just not.
About carrying dangerous weapon?
Again, I'm not, it wasn't before, not part of the case. I'm not prepared to say whether that would or would not qualify as a violent crime under the force clause.
But your view is that even if it arguably would be knocked out by McCarthy, that the plea essentially waives that claim?
Yes, and if you go to the ineffective assistance, that the defendant suffered no prejudice because he would be in the same position as he is now, being a ACC level 1. And as Judge Ricciardoni stated in his in the plea colloquy, the defendant that the plea counsel did, quote, a remarkable job in terms of leniency of the recommending sentence, giving the disastrous consequences of the defendant's actions. So I believe, even if you would say that adopting the ineffectiveness, he suffered no prejudice because he'd be in the same position as we are now with the level 1 ACC, with assault and battery as the predicate offense. If there's no further questions, the Commonwealth will rest on its brief.
Okay, thank you.
Thank you.